Some folks go through probate. It's not that big a deal. What could go wrong? Well, that's exactly what we're going to be talking about today. My name is Jim Miskell. I've been an attorney for more than 30 years in the state of Georgia, and this is my podcast, Let's Talk Estate Planning. I dream of a world where everyone has their estate planning in place so that when grief and crisis strike, when transitions occur, family members aren't stuck running around town trying to figure out how to do a bunch of administrative tasks. They get to spend time together supporting one another, which is what families ought to be able to do in those difficult times. As a reminder, this is not legal advice. The podcast is for informational, educational, and entertainment purposes, but it is not legal advice. Legal advice, just as a reminder, occurs when you are sitting in the room with an attorney. There's sort of this joke that no matter what question you ask an attorney, the response you're going to get is, well, it depends. And that's not a joke. That's no joke. It does depend. And when an attorney says it depends, the next thing out of their mouth is what it depends upon. And they're going to ask you some questions when you're in a counseling situation and give you an analysis of your situation and some advice. That happens when you're sitting across the desk from an attorney who you've hired to work on your situation. And this, although it's good information, and I want folks to really have some good information so they begin to get their planning in order, this time that we spend together does not constitute legal advice. So there you go. Our story today is a multi-generational story, and it's going to start with George and Martha Washington, not their real names, of course. But this is a couple who had some assets, not a huge estate, but some assets, and enough that they sat down to do wills a couple times over the years. And George and Martha were a subsequent marriage for both of them. George had George Jr., a son, and then Martha had three daughters that were stepkids for George. One passed away in her adulthood, having had three kids of her own, and so there were two living daughters and George Jr. George, if we're talking about probate, you know that these folks that I'm telling you about are going to be deceased as we go, and that happened with George in 2008. So George dies in 2008, has the year 2000 will. In that will, he appointed Martha to be his executor. And of course, they were kind of advanced age, of course, elderly at this point. If Martha was not able to serve, then he appointed a family friend who was also of advanced age. You may be wondering, well, why didn't he appoint his son, George Jr.? Well, George Jr. was in prison at that point in time. And you'll hear more about that and how that helps our story unfold as we go. But right now, George passed away in 2008. There's a year 2000 will. The year 2000 will is what you might call a sweetheart will. It says everything to my loving spouse, Martha, if she survives me. If Martha does not survive me, it said I want it to go in 3 equal shares to George Jr. and to my two stepdaughters, Martha's surviving daughters, Connie and Dee Dee. So that's it. Everything goes to Martha. And we've talked a lot about who gets notified of probates and those sorts of things in other episodes. In this case, when George died, it was Martha and George were the heirs at law. So they get notification of the process, of the probate process, once Martha files her petition. She, of course, acknowledges she filed the petition, so there's no issue with acknowledging it there. But George Jr. has to be served. And he's upset, of course, because his life hasn't gone very well. And from prison, he's got a lot of time. He's writing some caveats to the will, contesting the will. My stepmom's not treating me the way I should. She should. I'm not getting the things that I should be deserving, that kind of thing. And that goes on for several months. Martha, although it appears to me, looking at the court record, that she tried to file initially by herself, she ends up getting an attorney to help her through that process and defeat the caveats when you contest a will. It's formal name in Georgia, you call it a caveat, and there's a lot of defects in the way George Jr. has tried to do this. He hasn't paid the proper fees. He filed a pauper's affidavit, so he wouldn't have to pay the fees. Well, he didn't pay the fee for the pauper's affidavit. In any event, furthermore, he doesn't really have any reason to contest the will, except he doesn't like what's happening, and he feels isolated because he's in prison. He doesn't really have a good reason. He just doesn't like what's going on, and he's got a lot of time on his hands to think about it. But that sort of gets a little bit protracted, but eventually George dies in 2008, early 2008, late 2008. She gets letters testamentary, which is the order from the court saying, hey, this 2008, or rather 2000 will, no problems with it. You're good to go. Martha, go ahead and administer the estate, which of course is, as we said, a sweetheart will. George saying everything going to my loving spouse, Martha. And so she rocks on and she takes care of business and continues her life and goes along. And in the meantime, let me introduce to you the next level of the family. We're working on it. So far, we had George and Martha and George Jr. This is about the last we're going to hear from him in the story. He files a caveat, slows it down a little bit, but the letters do issue with the help of an attorney getting involved and getting that down. So getting that done so Martha can handle the part that she needs to. Martha has Connie and Dee Dee. Her other daughter, Tina, predeceased her, and she has 3 kids. And for purposes of our exercise today, we're going to call them Huey, Dewey, and Louie. So we've got the grandkids, Huey, Dewey, Louie, Connie, and Dee Dee. And so Martha, upon advice from the attorney that helped her with George's probate, she realizes this is a good time to redo a will because her prior will said everything to my loving husband, George, and he has passed away. So in 2008, while all this probate's going on, she's inspired to update her planning by signing another will in 2008. That will says everything to my daughters, Connie and Dee Dee. She makes no provisions for Huey, Dewey, and Louie, Tina's kids, just to Connie and Dee Dee. And so that's the setting the family remains in until Martha's death in 2021. And so when Martha passes away in 2021 at an advanced age, and, when she passes away in 2021, Connie and Dee Dee, well, heck, they're 71 and 74, I think, at that point in time. So they're of somewhat advanced age as well. When Martha passes away, there's not a lot left in the estate at the end of the day, except the house that George and Martha resided in. And other property, it's all distributed, all taken care of. How did that happen? Well, remember, we've got the 2008 will. So when Martha dies in 2021, you need a scorecard for this. I had to write all this stuff down to keep track of this. I've been following this along in the office. And of course, the names have been changed to protect the identities of our clients, but this is based on a case we've actually been working through with the family. In any event, Martha dies in 2021. The 2008 will is offered for probate by her daughter, Dee Dee. Dee Dee is the named executor there. At that time, like I said, 74, 75 years old. And she files that herself. Again, we've got, I look back at the court records. We weren't involved in that point in time. She files the petition herself, it looks like in February of 2021. And then there's a series of sort of corrections that take place. She files it, clerk accepts it, then she gets an order that, hey, your petition's deficient. That comes along in March. And so she has to update her petition. She gets around to doing that in May. And then May, and all this is that's 2022 by the time the petition's amended. Then she has to notify the heirs. So we're looking back at Martha, who's left at this point. It's Connie, Dee Dee, Huey, Dewey, and Louie. Huey, Dewey, and Louie are left out of this will. Martha chose not to do thirds to Connie, Tina, and Dee Dee. Tina, her deceased daughter, she just went halves to Connie and Dee Dee. So that's the situation. And you see, even back in 2021 and 2022, Huey, Dewey, and Louie are not amused, and they're not very excited about participating in this process. They don't hear from this side of the family very often, and they're suspicious, and they're stop calling my phone and all that kind of thing, to the extent that Dee Dee moves to serve some of those folks by publication. And that's what happens when you can't actually get service acknowledgement signed by people who you need to notify these things. You ask the judge, you say, look, we've done everything we can. And that's kind of a high bar. Judges don't really care for service by publication except as a last resort. You have to show you've exhausted every possibility. So you have to do a lot of showings to do this. In any event, all that finally gets sorted out, and letters do issue for Dee Dee. She gets the letters to handle Martha's estate, and whatever's in the estate she distributes to herself and her sister. They're both in their 70s, whatever property it is. But she kind of runs out of gas, and she's not very motivated to do anything with the house that had been George and Martha's residence. So that's sort of sitting in the estate. So they just sort of rock along for a while. In the meantime, Connie, the other sister, has two kids, Dan and Robert. Dan lives locally. He's like, hey, what are we doing with Grandma and Grandpa's house? It's just sitting there. And his mom said, well, that thing is, nobody's lived in it in a while, and it's sort of run down. I'm not interested in fixing it up. And Dee Dee, my sister, she's not interested in fixing it up or doing anything. He said, well, I could do something with that. I think that house would be something that I could fix up, and I'd enjoy doing that. So Connie and Dee Dee talk to their son and nephew, Dan, and say, you know what? If you want it, you can have it. We're not doing anything with it. We don't plan to do anything with it. You can do it. But at this point, Dee Dee is getting of advanced years. And this is 2024. She's 78 and says, well, I can't do anything more on the estate. And Dan says, well, how about if I take over your role as executor for Martha's estate? And so she says, great, happy to do it. She signs the paperwork resigning as Martha's executor, and says, I want Dee Dee. Man, this is a lot. This is a lot. George is trying to get George and Martha's house. And I've already introduced you to three. Don't worry, you're going to meet the fourth generation. In any event, Dee Dee steps aside so that Dan can become the executor in her place of Martha's estate, so that house can go to Dan so he can fix it up and do whatever he wants to do, because Connie and Dee Dee are fine. You happy for you to have it. Hope you can enjoy it. She not only has to resign, but you may recall that I may not have mentioned it, but Martha's will said, I want Dee Dee to be my executor. If Dee Dee is unable or unwilling, then I want Connie to do it. So Dee Dee resigned because she actually had letters testamentary. But then Connie also had to sign off and say, I don't need to do it. Dan's going to do it. I'm 73. I'm out. Go ahead and do that. So Dan actually gets that accomplished, and we help Dan through that process. And in that process, we're back trying to get Huey, Dewey, and Louie to consent, and more texting. Why are you calling me? Quit calling me. Because Dan reaches out to them, and he's like, I'm going to block you, and don't block me. I'm your cousin, and here's what's going on. And finally, get through whatever needs to happen with notice, publication, all those things. It takes several months, but in 2024, Dan becomes the executor for Martha's estate, so that that house that George and Martha have lived in can go to him, and he can do that. So he can improve it and do what he needs to do with it. So with the blessing of Connie and Dee Dee. So he's getting ready to do this, and it should be pretty simple because George died way back in 2008. Certainly there's nothing left in his estate. Well, unfortunately, what Dan discovers is that George and Martha's deed was not a survivorship deed. And it's called different things in different states. Sometimes it's tenants by the entirety. Sometimes it's joint tenants with right of survivorship. Sometimes it's just a marital deed. But in any event, the deed that they did, the formulation in Georgia, meant that half of the house was in Georgia's name and half of the house was in Martha's estate. Martha didn't understand this because, again, she was trying to do this without a lawyer. She got the lawyer's help to get the letters, but then kind of took it over on her own and never really finished up getting George's half out of his estate and into her estate. So Dan is faced with this proposition now where he has to get letters. He's been appointed in Martha's estate, but he's found out he can't transfer the house to himself because half of it is still in George's estate. So now he has to go back and file another petition to take over Martha's place in George's estate. Martha was the first executor in that year 2000 will. And that will said, if Martha's not able to do it, then it's our best friend, Richard. Now, Richard is deceased long time at this point. And Dan shows this to the court. Richard's deceased. He can't do it. I'd like to do it. Again, he has to get the consent from the people who are the beneficiaries of the will and the heirs. So that we got Connie and Dee Dee and Huey, Dewey, and Louie, who were Tina's kids, are all involved giving consent to do that. Martha needs to consent to that. She's deceased. And so only once Dan gets appointed the representative of Martha's estate can he consent on Martha's behalf to somebody new taking over George's estate. This takes many, many months, and it finally gets all done. It starts in 2024 and all the way through 2025. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestatesplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So let's talk estateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. Along this way, in our meetings with Dan, he's like, man, this is crazy. I am definitely going to do a living trust because he'd been to the workshop. He understood what we'd done. We'd actually done some planning for the other side of Dan's family. That's how we met Dan, with some trust planning. And he was impressed that what we did for the other side of the family was not going to run through the probate courts like this. And he said, we're going to set up an appointment, Dan and his wife, Becky, to come in and get his planning in place. I said, let's go ahead and do that. You don't have to wait. No, I got a lot going on. But don't worry, as soon as I get all this wrapped up. You know what happens every time I tell you that somebody says, no, I got a lot going on. We're going to put that on. Every time I say that, you know that the next part of the story, well, we'll just leave that for a minute. Dan, he's now serving as executor for George's estate and for Martha's estate. He finally is able to deed the house out of George and Martha's estate into Connie and Dee Dee's name. Connie and Dee Dee, that's Connie's his mom, Dee Dee's his aunt. They say, no problem, get in our name. We'll sign it over to you. No problem. He gets it into Connie and Dee Dee's name. He's working on preparing the deed from Connie and Dee Dee to himself and his mom at 76 years old in 2025. She dies. So Dan knows, unfortunately, what to do. Connie died in 2025. She had done a will in early 2025, I think, reflecting upon and having some conversations with Dan. His mom, you don't have any planning in place. You need to get at least some basics. And there's a basic will that she did in 2025 that said, any interest I've got in that house that was George and Martha's that I've inherited, I want that to go to Dan. And the rest to be divided. The interest in the house to Dan the rest of her estate to be divided between Dan and Robert, his brother, Dan and Rob. So Dan probates. He's getting to be a regular over at the county probate court, and he's familiar with the situation. He knows what he needs to do. He files a petition to probate Connie's will. He needs to notify his brother Robert. They both acknowledge everything's fine. They consent. Dan gets letters testamentary for Connie. So that takes care of Connie's half of the deed. He's going to be able to transfer him to himself as executor's deed, and he'll follow the provisions of her will that say that inherited property, I want to go to my son Dan, and everything else divided between Dan and Robert. So he gets letters testamentary, and he's all set. And one thing I had not mentioned is that Dee Dee lived in Alabama, a neighboring state. So she didn't actually live in Georgia. So when Dan got everything set to go, it had slowed down by having to become executor for his mom, Connie. He gets ready to go to see his Aunt Dee Dee because he's got the deed for her to sign. Just like she's always said, Dan, you can have that property. I hope you enjoy it. She ends up in the hospital. She's starting to have some health issues because she's 79. And the day he drives over to see her to get the deed signed, she's already in the hospital. She dies before he gets the deed signed. So he's done all this work. He's become executor for both Grandma Martha and Grandpa George. He's had to become executor for Connie. He's had to deal with Tina's kids who are not amenable and very happy about any of this process. There's publication involved and convincing the court that that's okay to do. He's getting all this done, and he's right on the verge of doing it, and Dee Dee passes away. Now, here's the thing. Dan does not know whether or not this house is in her will. He just had verbal agreements with her, just a conversation where she said, of course, Dan, you've always been a go-getter. You enjoy that house. My sister Connie, your mom, and I, we don't want it. There you go. So everything sort of comes to a stop. Dee Dee dies in 2025, not long after Dan is appointed or gets letters testamentary for his mom's estate as her executor. So this would be a good time, of course, for Dan and Becky to come in and get their trust planning in place, and that would be a great thing to tell you is what happened next. But, as my stories always do, it tends to lead to somebody dying without planning. And this is unbelievable. This is like a law school exam of question, hypothetical. But this actually happened while Dan is trying to deal with Dee Dee's kids. She's got Cindy and Bobby, who are young adults over in Alabama. He's trying to figure out the next move. Puts it off. I've got my business. He runs a little business on his own, and he and Becky, we're going to make time. Gets in, but we got some bad news one day that Dan has had a heart attack and he's died. So now what? Because we got the house into Connie and Dee Dee's name. Connie died. Dee Dee was died before she. That's confusing. Dee Dee died before she could sign off. Connie died before she could sign off. Dan had become executor for Connie's estate. Now, all this is interesting, but real life, this sort of not a hypothetical, but all the family tree and how all this works and how it works in court is great. But there's a lot of things happening outside of court. Throughout this period of time, I alluded to you that this house has been vacant since before 2021 because Martha didn't live in it till her death. She had to move out because her health was failing. It's been vacant for quite some time. We've had some severe storms come through the Atlanta area, and a tree falls on the roof. Now, the tree fell on the roof of this house before Dan was even appointed executor in Martha's estate. And this is sort of what drove it. The tree on the house is what sort of spurred him to get involved and go, what are you, Mom and Aunt Dee Dee, what are you doing about that house? Because it's just sitting out there. And because they called him and neighbors got in touch with the family, he goes over there, gets the tree off the house, gets a tarp on the roof, but he doesn't actually have any authority to do that. He's out on his own, spending his own money to do this. Insurance coverage is always in question when a house becomes vacant and when the owner has passed away. He doesn't know what George and Martha did as far as insurance. He doesn't know what Dee Dee, as executor for Martha's estate, has done. So he's got to get that insurance situation sort of squared away. He doesn't actually have any authority because he doesn't yet have letters testamentary in Martha's estate or in George's, because remember, that house is still half in George's estate. So he's not really on legal footing to get anything done, and he does the best he can, but it's money out of his pocket and some understanding insurance folks getting some coverage on that thing. And he finally repairs the roof out of his own pocket so that environmental damage doesn't continue to happen to the family, so it doesn't to the house, so it doesn't continue to rain in there. All this is going on while he's wrestling with judges that okay to do publication. Well, I don't. Well, Huey Louie won't respond to me. Well, you need to do better. You need to try the X, Y, and Z before I'll agree to publication. And this is all what slows the process down, because you can look at it on paper and say, this is what the family tree is, and this is how things should go. This is how authority. But in real life, you can't do any of those things until the court process has worked and the judge has signed off on it. And that's where this process slows down into weeks and months and years. After all the hard work that Dan did, he died. Now, he's got an estate that's going all to Becky. He's got just a basic will. And she's grieving. She's lost her husband. She's not ready to step into George and Martha's estate and Connie's estate and deal with the folks on Dee Dee's estate. She's an in-law. She's not even blood relation. And, you know, just the way Huey, Dewey, and Louie, Tina's kids, are kind of standoffish. You're getting the same vibes now from Dee Dee's kids, Bobby and Cindy. They're not really excited about dealing with this side of the family that's still in Georgia. They're over in Alabama. They're Dee Dee's family. We don't care what my mom told you. You know, do you have it in writing? No. And, well, her will doesn't say that you get the house. All right. So maybe he gets a half interest in the house. Well, but he's passed away. So maybe his estate gets a half interest in the house. Dan's brother, Robert, who in the meantime is running his own life. He's got his own family and wife and business. He agrees to step up. He said, I will finish what my brother started. And so we begin the process of petitioning the court for Robert, for Bob, to substitute for Dan in Martha's estate, Grandma Martha, for Grandpa George. We want Robert to step into Dan's shoes with no benefit to himself. Everything he understands is going into Dan's estate for Becky, his sister-in-law, for her benefit. And he's comfortable with that, but he's willing to step up and do this thing. And of course, I left one out. Not only is he stepping into Dan's role in George's estate and Martha's estate, but also in Connie's estate, their mom's estate. And so we file substitutions for all those things. And we expect that all to go pretty easily. And, you know, the Dee Dee's kids will say whatever they say. Maybe we're doing publication there. Maybe they'll sign off. Who knows? But it's definitely in question whether or not that half of the house, now another generation down, they're still comfortable going to their cousin Dan over in Georgia. This is where it gets really interesting, because Cindy, who's Dee Dee's daughter, this would be Dan and Bob's cousin over in Alabama, her boyfriend, Ricky Bobby over in Alabama, he wants to go ahead and be involved. He inserts himself by filing a petition in Martha's estate to take over from Dan. He files this petition the day that the death certificate comes back for Dan. So like days after his death, Ricky Bobby's already filing to become executor for his girlfriend's grandmother's estate. This is great. This is just going to make everybody happy. So here's the thing. there's actually nothing left in Martha's estate. The only thing left to do with Martha's estate is to close it. But before they close it, they've got to get George's estate closed because there's nothing left in that estate either. Well, Ricky Bobby doesn't know anything about how Georgia probate works. He doesn't know how anything Georgia probate works. He just knows he wants to get what Cindy's deserved. So he files this petition so Ricky Bobby, he's going to be the executor and he's going to protect Cindy's interest. Great. So at this point, things are all up in the air, but I'll tell you what the next step is that Bob, Dan's brother, is just resigning and going to let this thing work out however it works. If TD's family's that interested in it, they can do it. He's told Becky he'll support her any way that he can. And Becky may have some interest now at this point of stepping forward and doing it. But right after Dan died, she was not in a position to do that. She was grieving too hard. And that's one of the aspects about probate that makes it so difficult, is that very often the people appointed as executors are the people who are grieving the most after somebody dies. And when Dan died, Becky was in no shape to say, hey, yeah, I'm ready. Let me be executor for all this extended family and take on what Dan was doing. I think at this point she might be ready to. But in any event, the end of this is uncertain. What I do know is that Becky is having to go through a probate process of her own on Dan's estate because they delayed. And even though it was really clear to Dan that probate's no fun, and man, we should do a trust like my folks did, like my dad and my stepmom did, sure, we'll make things easier, and we're going to do it. We're going to get in there and do it. I mean it. Just got a lot going on right now. When I hear people say things like that, I just kind of hold my breath. I hope they come in. I want to get it done because you remember that I have a dream that everybody gets their estate planning done so that families in time of grief and crisis and transition aren't running around town trying to do administrative stuff, not trying to figure out how to put a tarp on a roof where you don't have any legal standing, trying to talk a roofer into put a new roof on a house where the ownership is uncertain. And then taking all this stuff over for a deceased relative who was in the middle of doing something and didn't finish, and you got to try and pick up all the pieces and go on. So if you're interested in how probate works, particularly in Georgia, there are some other episodes of the podcast that you can visit with and learn that. But this was one that really stood out to me because, like I said, it's like a law school exam hypothetical that you can't believe all these things are happening in the same set of circumstances. And as I look at that county's probate court records, and we've pulled the pleadings that were filed before, as I say, as Martha filed things to start with, there are corrections requested from the court and amendments requested. But this is deficient. You need more. We need more information on this. You need to formalize this because it's actually a formal court proceeding. And you can say, well, yeah, it's just form process. It's going to be easy and everything. But we have a pretty thriving probate business because very often it's not as simple as people think it is. I would say 20 to 25% of the folks that hire us for probate do so after they've begun on their own and they hit a roadblock that they didn't expect to do that. And I talk about it a lot, that common sense is over here, how you expect things to work, how things should work. Anybody would understand that that's how things work. And there's the law. And sometimes part of the law overlaps common sense and sometimes it doesn't. And there may be good reasons why the law doesn't follow common sense, but unless you're involved in it all the time, unless you're a lawyer, unless you do it a lot, why would you know that? And that's when probates get protracted and difficult, and delay causes hurt feelings and difficulties in relationships because people don't really know what to expect. And one of the difficulties with probate is that there's an uncertainty in the timeline. And although the probate courts, the judges and clerks are doing their level best for everybody that comes in front of them, there are legal requirements that have to be met that can cause delay. And, is somebody in prison? Is somebody not going to respond to service? All these things can factor in. Thank you for spending some time with me today. This was one that was just so wild. I wanted to tell you about it. I hope you found it interesting. If this has made you say, man, I need to talk to a lawyer about this, if you're in the state of Georgia, set an appointment with my office. I'd be happy to sit across the desk from you and answer your questions with, it depends. But after I say it depends, I'm going to ask you some questions and get the details so I can give you an assessment of your situation. Whether it's probate, a situation you're already in, or planning, get in front of a good, experienced estate planning attorney. If you're in Georgia, I'd love to sit with you or have one of our other attorneys sit with you and get through all your questions so that we can get your planning up to date and in order, so that when grief and crisis strikes, your family's not running around town trying to figure out a bunch of administrative tasks. Take care of yourselves. Thanks so much for joining me. I'm Jim Miskell. You guys have a great day.